Nate, it seems like we are all set with you, with everything that I have for you for now. Uh, Judge, I think for now, I might, if there's any opportunity for a rebuttal, I'm
Okay.
off. Thank you.
All right. I just have one question before I turn it over to Attorney Bullocks. Were you involved in the decision to terminate Mr. Michel's employment?
Yes, I was.
What was your involvement?
My involvement was initial fact finding of the last incident between him and Mr. Morris, as well as another couple complaints that have come up, and then the recommendation to my supervisors.
So you recommended that his employment be terminated?
Yes.
Right. Attorney Bullocks, you can go ahead with any cross you may have.
Sure, just a few questions here, and then again, we'll reserve our other questions for our case in chief if we get there. Um, so Nate, you mentioned earlier that you talked to Mr. Michel about an incident in which he reported that Barb McDonald hit him. Is that correct?
That is correct, yes.
Okay. And at this point, Judge, can we pull up exhibit number 15?
Sure, just one second. So that should be on the screen.
Okay, so this is the document that I think Mr. Michel was going over with you when you were having that discussion. Is this your handwriting on this document, just so that we're clear?
Yes, it is.
Okay. And it was noted earlier that that it's not dated. Is that correct, your handwriting?
That is correct, yes.
Okay. When did you take these notes?
Would have been probably a day or two after. Like I said earlier, I take it an urgent matter in any confrontations within the branches I was responsible for.
Okay, so it was at or around the time that you had the discussion with Willie about this?
Absolutely, yes. It would have been during that discussion.
Okay, great. And you went over it a little bit earlier, but if you can physically kind of demonstrate for us what Mr. Michel showed you when he was discussing um, the hit from Barb.
So again, it would have been, hand looks huge. It would have been a open hand hit, like a tap or a brush, something like that. Is what he displayed to me was the physical contact.
All right. Judge, you can take that one down.
Okay.
All right. You testified earlier as well that Barbara helped out, and I have, quote, a few days at the De Pere branch during the time that Mr. Michael was assigned to the De Pere branch. Is that correct?
Correct.
Okay. A few days to me denotes something small. Is that, am I misinterpreting that?
No, that would have been a shorter term, few days, maybe a week tops.
Okay. And also, Nate, in your testimony earlier, you talked about hiring Sarah Nook into the assistant manager role in De Pere. Do you recall that?
Yes, I do.
Okay. And then I believe Mr. Michel asked you to confirm that Sarah Nook was also hired at the same time he was hired. Is that correct?
That is correct, yes.
Okay. And were they
Roughly right
hired
around
at
the
the,
same time.
all right. And were they hired at the same level?
No, they were not.
Okay. What was Mr. Michel hired into?
Mr. Michaud was hired as a universal banker, float
Okay.
position.
All right. And what was Sarah Nook hired into?
Assistant branch manager.
Okay, so at the time that she assumed the assistant branch manager role in De Pere, she was already an assistant manager at the bank.
That is correct, yes.
Okay, and why did you hire her as an assistant manager at the bank when she was first hired?
I believe she had prior banking and leadership experience.
Okay, and is that something that you recall Mr. Michelle had as well?
There was no banking and there was no leadership experience in his background that he provided.
Okay. At this point, that is all the questions I have. Again, reserving our right to call him during our case in chief.
I just have another question based on something you just said. You said that Barbara McDonald helped out at the De Pere branch for maybe a week tops. Do you know if that was at the same time that Christopher Morris was working at that branch?
I do not recall.
Okay. Mr. Michelle, do you have any other questions for Mr. Vanden Branden?
It's I have some rebuttal that with some of the questions that I have. I think at some point we'll have me time for that.
But
But
do you have questions for him?
um,
We're still in just the questioning him at this point.
if you can bring the determination letter, please.
Just
Probably
one
with the
sec.
questions on that, and then we can move on.
I gotta figure out what exhibit that is again. Just 1 second.
I think it's exhibit number 4 of respondents. I'm going
Okay.
off of memory, but let me
Okay.
check.
I think that looks right.
Yep, that is it.
So, okay, so that is on the screen now.
It hasn't showed yet, just that you're
Oh,
aware.
sorry. I keep forgetting to hit share. It's showing on my screen, but not anybody else's. Now it should be up.
Okay, thank you. And briefly, we're just gonna go over that, okay? And I'm just gonna have you, if you can please read it over and aloud.
The entire letter.
Yes, that's fine.
Dear Willie, this letter serves as confirmation of our discussion Wednesday, October 11th, 2017 regarding your employment with Associated Bank. We have had several conversations and coaching with you over the last year regarding appropriate conversations with colleagues within the workplace. Specifically on April 19th, 2017, you received a follow-up email from your manager, Megan, informing you that Associated Bank will respond to inappropriate behavior in the workplace. It also states that you needed to be aware of how messages and conversations may be perceived. Even if there is no intent to be offensive, it may be taken such by the receiving party. On September 26, 2017, you were frustrated with a colleague that you felt stepped into your conversation with a customer. After you had concluded your conversation with the customer, you called the colleague into the office. At that time, you stated to the colleague that they will not do that to you again. The conversation continued with the colleague, and when the colleague started to feel uncomfortable that the colleague was escalating, he opened the door to the office and exited. You followed the colleague into the branch lobby where other colleagues could hear your raised voice during the conversation. You were also physically close to that colleague, which was making the conversation very uncomfortable. Hold on, it's going.
Yep, I wanted to move it down.
No, appreciate that. Just took a little bit on my side. When this was discussed with you on September 28th, you were still very frustrated with the colleague and stated that you just wanted it to stop. This was the final one. You stated that you were stern and you wanted it to stop because you needed to continue because we needed to continue the investigation. You were placed on paid suspension. You were also scheduled for paid time off. We discussed that we'd follow up with you once you return from PTO. On Tuesday, October 10th, I scheduled a meeting with you, Jeff Schofield, District Manager, and Nicole Gerke, HR Business Partner, for October 11th. During that meeting, you did not provide any indication that you would take different actions if faced with the situation again. The inability of you to recognize you acted inappropriately in the work setting is concerning further, and based on your responses in the October 11th meeting, it is our conclusion that you are unwilling to change your behaviors when you are frustrated with colleagues. Even though you have been coached multiple times to involve your manager to assist with problem resolution, your behaviors are considered unprofessional and disrespectful and will no longer be tolerated in the workplace. As a result of your continued unprofessional behavior, we terminate your employment effective as of October 11th, 2017. You will receive any applicable benefit paperwork from Colleague Care. If you have any questions regarding that information, please contact Colleague Care directly at 800-878-3282, option 1. If you have any questions about your separation from employment with Associated Bank, you can contact me at 608-745-5584. Sincerely, Mary Cottington.
Thank you very much. Judge, you can go to the very top now, please. The very top.
Okay.
Thank you. And with that being said, Nate, you just mentioned earlier that you were part of the decision to terminate me, correct? You just
I was part of the initial fact-finding determination, yes.
Yeah, and what you just read, you get a good handle of what you just read here. This is the cause of my termination, correct? You get a good
Correct,
handle.
yes.
I'm familiar with that. Yeah. I'm just gonna go to the very first page. Now I'm gonna read it for you. That's okay, to get an understanding. We have several conversations and coaching with you over the last year regarding appropriate conversation with colleagues within the workplace, specifically on April 19, 2017. That date, April 19, 2017, you recall that was the Rachel Favor complaint of inappropriate text? You recall that?
Yes, I do.
You recall that you were the one that came to the office and pulled me in with Megan to discuss that?
Yes, I do recall that.
Okay. A few facts already been established on that, and that's already part of the record. Okay, I will let you understand that. That it's been established that there was no text to show regarding those communication. Also, earlier as part of the record, it was also mentioned that there was no substantial, there was no substance. The sexual harassment was not substantiated. Okay.
Okay.
But however, I still get coached forward because he mentioned that. So where I'm going with this, what I meant to ask you there is that I see this is part of it. Okay, back there, that's the ensemble of act of infraction that I do. That is correct. That is my understanding. Is that also your understanding there with that?
Object compound.
Okay.
Could you rephrase your question, Mr. Michelle?
Definitely, I'll make it more sure. That paragraph that I just read, okay, this is part of the decision for my termination, correct?
This and other
You can answer by yes or no.
complaints.
You can
Yes.
just answer yes or no. I don't want it to go far. And I will ask you, because also you came to the branch often, you were there part also with the case with Mr. Moss. Did you take any type of, on your own part, as a manager, to have independent type of evidence, if you will, recording other than witness statement? Did you attempt that? Did you attempt
Did I
that?
attempt to record anything? No, I did not.
Exactly. So did you attempt to surreptitiously, either in person, to notice what, come and visit the branch, for example, come, you know what I mean, to see, to notice what happened? Did you attempt anything like that at all, to have independent?
After the complaint was filed to me by Mr. Morris, I believe it was in the branch either the next day, to have discussions with everybody in person.
Let me just rephrase. I'm going to make the question shorter. I said, did you surreptitiously like kind of in hiding, like to try to investigate without nobody
Are you asking
knowing.
if I hid in the branch to investigate? No, I did not.
Yeah, kind of coming to the shop independently. Okay, that's where I'm going. You see what I mean? Not just witness statements that you can see something happen. And that's in regard to me bursting out and yelling, correct? Mainly my behavior yelling. That's the
The
allegation with
statements that I
Mr. Moss.
received, yes.
Okay, yelling at him. Okay. That's everything here. Thank you much. That's all I have.
Anything else from you, Attorney Bullocks?
Yeah, just real quick on the termination letter we were just looking at. Nate, if you can look at that first or second, I guess, full paragraph that we were just talking about. And do you see where it reads, it also states that you needed to be aware of how messages and conversations may be perceived, even if there is no intent to be offensive, it may be taken as such by the receiving party. Do you see that?
Yes, I do.
Okay, and there's a point of this to further kind of elaborate on the need for Mr. Michelle to have appropriate conversations in the workplace.
Absolutely.
Okay, and to be aware of how his messages or actions um, may affect others.
Yes.
Okay, and even if it's not his intent, how certain things he does can be um, perceived a certain way.
It can be, yes.
Okay, and then this is an example of a coaching that was given to him in connection with that, correct?
Correct, yes.
Okay, and this is not saying that he's being held accountable for any type of sexual harassment or misconduct against a female colleague, is it?
No.
Okay, all right. I don't have any other questions
Do you
at
have
this
any other?
point, but I
Yeah,
will reserve.
sure. Do you have any other questions, Mr. Michelle?
Not at this time, Judge.
All right. Then, Mr. Vanden Brandon, I think we'll be calling you back in a little bit to continue with your testimony. But for now, you're free to disconnect, and then someone will be in contact with you when you need to reconnect in a little bit.
Okay.
Thank you.
Thank you.
All right.
So, Mr. Michelle, now if there's any additional testimony you wanted to provide before you rest your case, this would be the time to do it.
What I did have, Judge, is that when I was questioning Ms. Connington on direct, it's just some discrepancy that I would like to rebut on
Sure, that's fine.
on at least one question that she said. Ms. Connington did advise that, I believe on February 8th, the date, I did not jot them down, that that I suggesting what I need is for a transfer. I want to rebut to that. I never mentioned that. No, it was not my decision. That did not come out of my mouth. That's enough. I want to rebut to that. That was not the case on December 8th. And as a matter of fact, the record would show also it's been established under oath that Nate proposed that to me. And let me just go down to see what I jotted down here. Also, I would mention regarding the conversation what I have at Mr. Nate on direct, that he mentioned in one of his answers that he mentioned that he came back to the branch to talk to me regarding the position assistant manager. That never happened. That would ever have an in-person connection, in-person face-to-face kind of. You did not get it, the position. That is everything that I have based on the question that I want to mention.
So you have no other evidence at this point that you're going to present in your case?
No, not to. It's just that as you did mention before that I close, I'm kind of a briefing, a summary of everything. That's all.
Okay. I just want to make sure. I've been kind of following the yesterday and then today with regards to the exhibits that you referenced. I did play the recording, so that is part of the record, and I did admit into evidence the text messages, that extra document. I've noted that for my records as Exhibit 10, just kind of following in order, and the recording I noted just on my sheet as Exhibit 8. And then the only other exhibit that I've noted that we referenced during your case then is the what was identified as complainants exhibit 1. And I think it was just a few exhibits in there that we referenced, and some of them I think were actually referenced as part of the respondents exhibits as well. We talked about this morning that page 5 of the position statement. And then I have as well the exhibits that were marked as R, U, and V to that position statement. Are there any other documents that I'm missing? Because I think those are the only ones that you've referenced here, other than the respondents exhibits. I'm just focusing in on what was identified by you, Mr. Michelle.
That's all I have to use. I know I did send emails from.
Mm-hmm.
There's no need. As you can see,
Okay.
there's no need for them. I use everything, that I needed to use for that
Okay.
purpose. Yeah.
So then, Attorney Bullock, did you have any objections to my receiving those pages that I referenced in Exhibit 1, Complainants Exhibit 1, into the record?
Yes, with the position statement, we would object to anything from that being submitted. It's a hearsay document, and it was prepared by someone who is not testifying. There's multiple layers of hearsay in that document. There's been no foundation or testimony about why certain comments or statements were made in that document. And if you bear with me 1 second. So those will be my objections. If that position statement or any part of it is included, I would request that page 1 be included as well, which has a footnote in which it indicates that the information in it is confidential and that the information may be supplemented as matters progress.
I'll receive it. I'll note your objections. I think really what I was focusing in on and what I will be focusing in on in that document was what Mr. Michelle discussed with Ms. Coddington this morning, that one page 5, that statement. I'm not going to really do much more than with that exhibit other than what was referenced during the testimony for the witnesses. So,
Okay, fair enough. And then
but that
Judge,
go ahead.
the only other item is I think you gave one of Mr. Michelle's exhibits, exhibit number 8. I do plan on using our exhibit number 8, respondents exhibit number 8, as part of our case in chief, and I just don't want to, I guess, create any confusion.
No,
I
I
can,
labeled it as Complainants Exhibit 8.
okay, fair
So,
enough. Okay,
yep,
all
yep.
right.
And then the same thing with the text messages, that those 3 pages, I labeled that as Complainants Exhibit 10. So to differentiate between your exhibits and his exhibits.
Okay, fair enough. All right, thanks.
Does anybody need a break? I know Attorney Bullock, you were thinking of doing some kind of motion. Did you want to do that and then take a break, or how do you want to proceed?
Yeah, we can take a quick break and then, come back and I'll do my motion, and then if we need to go forward, we will from there.
Okay. How about if we take about a 5-minute break or so, come back at about 2:30?
Okay, sounds fair.
All
Sounds good.
right, thanks.
All right.
All right, so we'll go back on the record, and Attorney Bullocks, whenever you're ready, if you want to make your motion, you can go ahead.
Sure, thank you, Judge. So the bank at this time moves to dismiss Mr. Michelle's claims on all accounts. First, with respect to the harassment claims, there's different alleged harassers in this case. In Green Bay, it was allegedly Barbara McDonald and Kyle Paulson. In De Pere, it was allegedly Chris Morse. Different harassers, different claims of harassment. And because the first claim of harassment allegedly occurred when Mr. Michael was in the Green Bay branch, is time barred and cannot be considered as part of this case. As mentioned, I think earlier today in discussion or yesterday in discussion about the ERD's decision on the preliminary appeal. Any discrete acts of discrimination or unlawful activity that occurred prior to September 16th, 2017 are time barred. The evidence is that Mr. Michelle left the De Pere branch during the first part of 2017, and we went through written statements from Mr. Michelle where he indicated that the harassment that he experienced from Barbara and Kyle ended in February of 2017. He put it in writing. He confirmed that he wrote that. That testimony and his admission on that in that regard was in connection with a direct question that the ERD asked him in a request for information to list any and all acts of discrimination. So again, there's two different time periods in which harassment is alleged. One in Green Bay, the other in De Pere. They're both separate from each other. The alleged harassment in Green Bay is time barred and should not be considered in this case and should be dismissed. There is no continuing violation given that we're talking about two discrete acts of harassment. That all said, even if Mr. Michelle's claims of Barbara working temporarily in the De Pere branch is given any weight, there is no evidence that she was there after September 16, 2017, let alone that she harassed him, at all during this time. Further, any harassment claim that, involving Barb or Kyle, or any harassment that occurred at Green Bay, again, is untimely and cannot be considered as part of the case. That aside, Mr. Michelle's harassment claims fell as a matter of law, even if there were no timeliness issues. First, many of the incidents cannot be reasonably tied, judged to his race or some other protected status. For example, the December 17, 2015 email that Barb sent to Mr. Michelle about free logos and free shipping, which was Exhibit 18, in which he claims is an example of harassment, has no logical correlation to his race or his color or his national origin. And the same thing with the hat example that he provided, no correlation, no reasonable correlation or clear correlation at all to his race, his color, or his national origin. The alleged shove and physical assault by Barb, there's no correlation to his race, his color, or his national origin. And the same thing with the alleged interference with his customers, the alleged physical contact, again, with Barb, the alleged threatening posture that Kyle took against him. Nothing has no clear relationship to any protected characteristic that he belonged in. And he did testify during this case that he believed that the majority of the issues that he experienced was the result of him not following the directives of others. That may have been right, that may have been wrong, but it wasn't based on his race or color or national origin. To be actionable, any alleged harassment, any employment action must be directed at somebody because of their membership in a protected group. And there's a host of LRC cases on that very point, as well as federal cases. Most of the actions that we heard about over the course of the last 2 days have no connection to his membership in a protected group and therefore cannot support a hostile work environment claim that is actionable. In addition to all of that, the conduct alleged is not severe or pervasive enough to constitute unlawful harassment. For instance, he only mentions a handful of specific comments or actions. this is not enough to support a hostile claim, even if the alleged immigrant comment is considered. Courts in both LERC have held far more egregious and legitimately offensive conduct to be insufficient to maintain a hostile work environment claim. And I'll just give you one or two quick examples. So in a case out of the Seventh Circuit in 2009, Ford versus Metique, the case site is 587 F3rd 845. That court held that while ruled inoffensive, black man comments over a 14-month period in an affirmative action comment and a guerrilla comment directed at an African-American employee, whether considered separately or in an aggregate, did not support a legal claim for harassment. And then in a LERC case, Squirreling versus Swift Transportation, decided 13106. LERC held that alleged harasser's forceful touching to get the complainant's attention and being clothed in only his underwear in a sleeping compartment next to the complainant within the workspace was insufficient to support a severe and pervasive work environment. For all these reasons, regardless of the timeliness issues, there is no probable cause to find that Mr. Michel was harassed. On the suspension claim, the suspension was with pay. There was no tangible or financial impact on his employment. No adverse action equals no claim as a matter of law, and that claim should be dismissed. On the compensation claim issue, Mr. Michael had no evidence about the actual compensation of others. He had no evidence about the criteria used in making compensation decisions. He had no evidence about the qualifications and skill sets of comparators. He had no evidence of him being treated differently than similarly situated employees. Plus, he cannot dispute that non-Black employees who were universal bankers like he was were paid less than he was. He has presented no evidence to establish probable cause on the compensation claim. On his termination claim, he acknowledged receipt of the October 13th, 2017 letter, which summarized why he was terminated. That letter, among other things, noted his continued unprofessional behavior with colleagues, plural. Mr. Michael acknowledged that he had tension with multiple people in multiple branches. He also acknowledged that these concerns were reported to the bank and that multiple people alleged that he was the aggressor, that he yelled. As such, while he may disagree that he was the aggressor in his personal view, or that he was the source of the problem, the bank had very reasonable grounds to believe so, and there is nothing that he has put into evidence to suggest that the bank's reasons for terminating his employment, that continued unprofessional behavior that it believed was going on, is pretext for discrimination and not the real reason why he was terminated. The bank could have been wrong in reaching this conclusion, but it based its conclusion on the reports that it received and not his race or his national origin or his color. As such, we request that the termination claim be dismissed. And then for the retaliation claim, for the same reasons, we request that that be dismissed as well. For, again, the same reasons as the termination claim. Plus, there is no evidence of protected activity in connection with the first report that he filed to HR in February. He acknowledged that he did not mention his race or color or national origin. With his complaint or with his conversation with Jeff and Nicole Gorky, he didn't mention that his race or color or anything else was a concern for him. So there's no grounds for a retaliation claim. And finally, he was not and did not produce any evidence on the retaliation claim that a decision maker in connection with the retaliation claim knew about any instance in which he complained of race, color, or national origin discrimination. So for all those reasons, the retaliation claim should be dismissed as well, which I believe covers all of his claims.
Right, Mr. Michelle, do you have any response to what Attorney Bullock's just raised?
Um, uh, um, I just disagree with, of course, with what you say. I just disagree with it. What I will mention, that was pretty much part of my calling, is that I was discriminated against. It's because of my color and my national origin have something to do with based on the evidence that I presented, based on the statement that I make to the ERD. It's based on also statement that I have made of a physical assault, etc. It's based on that. That is my belief. This is what it is. It would have been different. It would have been very different that it would have been very different that if I was another color of another nationality, to be able to keep my job at this point. So I disagree with all that, and I will go further briefly to give a quick summary. Is that I have performed my job well. I respect everybody. There's nothing that I could do I did not provoke, and there's nothing that I could do on my power when I get picked on, when I get pushed aside. I always want to talk with Nate multiple times. I talk. I was very cautious also not to show that I'm after a case. You see what I mean? I just want to resolve things. I endure, and I seek every opportunity that I can when I talk either with Nate, to try to gain people in my favor. I get rebuked. It continues, that it get worse. When it came to the when it came to the um, when it came to the me being transferred, I did not ask to be transferred. It was offered to me by Nate when I make a final complaint. It was an email, as I allege. I know it's not there. I know it can be showed did not provide it. I don't have no control over that. I agree to be transferred again to seek a resolution. Is to seek a resolution, to seek peace, to stay away from the fear of being attacked all the time. As I get to the DPO branch, everything was fine for a moment. It was fine. Everything was fine for a moment until Barbara came in 2017 and suddenly assumed as a leadership position, work all out 2017, and train people that I done been training. I done been training Mr. Moss, as you can hear from the statement that I gave. He was a nice guy. But once Barbara came in with the innuendos, I started getting Mr. Moss become somebody else because he saw what Barbara is doing. He saw Barbara is still want to take over my station where I work. He saw Barbara redoing things purposely that I done right. Just redo it. He saw that. Mr. Moss then everybody else, but Mr. Moss specifically, that one of the main things I did put it in my statement everywhere. Daily, I receive mocking, a mocking that nonstop, that psychologically, mentally will break you. I'm talking with a customer, I get laughed at to the point the customer will think it's not them. As you can see in the recording that I play, I mentioned that actually that one time there's a customer that came to me and asked, what's wrong with this guy? She had a misunderstanding. Mr. Moss was laughing at me, mocking me. And I defend him because I'm representing the company as a professional. I said, oh no, he didn't mean that. But those are facts. It was me, Mr. Moss, mocking and laughing at daily, ridicule me. Barbara again continue with the same, taking over, shoving me aside, coming over. you can see a testimony that I would say includes testimony from even here Mrs. Covington that said that, well, the situation was not a good situation. Everybody was stressed, was frustrated. Then we put you aside, they were frustrated. Baba was frustrated, everybody was frustrated, we were frustrated. That's why you asked to go. That's why they sent you there. Then why Barbara didn't follow me there? If it was that the cause, if she was frustrated talking with me, if it was frustrated with me, why go again? There is a continuity, as it is mentioned on appeal. There is a continuity of the